pick up the 2007 Companies Law, please. Authorities, Bundle 1, Tab 4, at page 563. We can look at 34.2 and the permitted uses of the share premium account. And as my learned friend showed you, the permitted uses are now extremely broad. So some things have changed. Importantly, 2A, paying distributions or dividends to members, is something that under the previous law could not be done in respect of share premium account. The exception to the as-if capital rule did not apply for the purpose of making dividends or distributions. It only applied in respect of the particular uses that have been set out, including providing for the premium on the redemption of preference shares. But now, the legislature has opened up the use of the share premium account. It's not going to be treated as if capital at all, subject to a solvency requirement if it's going to be paid by way of a distribution or a dividend to members. But the pre-existing provision for providing for the premium payable on redemption or purchase of any shares or debentures of the company remains in exactly the same language as it was before. It would be strange if the use of the same language resulted in a different outcome as to the lawfulness of that use. But the other thing about 34.2 is that it now has in C permission to use in the manner provided in section 37. And my learned friend, when he took you to this, said, well, that must mean the manner provided in section 37.5. And I would agree with him. And we do know that that is subject to a solvency requirement. So there are two uses, A and C, which are subject to solvency requirements expressly. And there is one at F, for which there is certainly no express solvency requirement at all, and which never was in the same form subject to a solvency requirement. Now, my learned friend took you to the Court of Appeal judgment. I can deal with that.
Are you leaving section 34 at this point?
Well, no, because I wanted to take you to...
Because the main point against you on section 34, as I understand it, is that section 34 is concerned with the uses that may be made of the share premium account. It's not concerned with the question in what circumstances a redemption is permissible. It's only concerned with the question whether, if you have a permissible redemption, or it can be made out of the share premium account.
And as you will see, I don't disagree with that approach. I accept that one needs a lawful redemption before you can use share premium.
So we'll go back to 37 for the purpose of answering the critical question.
We will go to 37 for the purpose of answering the critical question. But the permission in 30, if you can use it under 37, indeed, if you must use it under 37 in some circumstances, then that use, so far as 34 is concerned, is not subject to solvency requirement. That's all at this stage that I'd want.
Well, it's not under Section 34, but it may be under Section 37.
And that would be the issue, of course. But so far as my Lord's first point to me was concerned, if Section 34 doesn't tell you whether the conditions of redemption are lawful, and I accept that you have to have a lawful redemption before you can lawfully use the share premium account for the purpose of paying a premium on the redemption of shares. But once you get that far, unless 37 itself imposes some separate solvency requirement, Section 34 itself doesn't. And it never did. That was always the case. The pre-existing law, the language was exactly the same, so far as 34 is concerned. You still had to have a valid redemption, but there was no solvency requirement.
And a lawful payment.
But the law didn't have solvency requirement.
You still have to have a lawful payment.
You've got to have a lawful payment, certainly.
Before it can be paid out of the share premium account.
Well, yes. I mean, we will... Of course, every step has to be lawful before you can use the gateway. But once the other gateways have been opened, then that gateway is not itself subject to a solvency requirement. I think that's as far as I would need to go at this point.
Can I just ask a different point? And I don't think Mr. Smith really emphasised this point, but in his case, he suggests that the proviso to Section 34, subsection T2, does introduce a solvency requirement because the words distribution or dividend to members, he suggests, would embrace not just A, but also would embrace F, the payment of the premium payable on redemption or purchase of any shares or debentures.
Yes, I think that wasn't his main point.
But he certainly, that's what he didn't really underline it today, but I assume it's still alive.
He raises that to stop me running for cover under A. I think that's why he raised it.
Stops you running for cover under...
Yes. In other words, so I can't rely on the general provision, which says, well, even if I can't make this payment by way of redemption, I can actually pay it to shareholders just by way of a distribution.
Yes, but isn't
because that is subject
the premium
to
payable, isn't the payment of a premium on a redemption normally to be regarded as a distribution?
Well, in one sense, at common law, it could be so regarded. The question is whether it's so regarded as a matter of construction of Section 34.
You say what to the words to members really here must be understood as meaning to current members rather than to people who have redeemed.
I think my primary argument, that's certainly what it says.
Just the words distribution.
My primary argument
doesn't
is
cover it.
It repeats the words distributions and dividends, because if that was right, F wouldn't be necessary at all. I mean, if F is to be encompassed in the statutory purpose of distributions and dividends, you just don't need it there.
It's not really the natural meaning of distribution, is it? I mean, a distribution, like a dividend with which it's coupled, is a payment made to somebody by virtue of his membership of the company. But a redemption is actually a surrender of all rights of membership in return for the value of the share.
Yes.
And I can't help feeling that there's a difference between these two things.
Yes, that difference, it may be what was, to some extent, behind the permission to use share premium account in the context of redemptions of shares, because it was to do with someone ceasing to be a member rather than some ongoing basis on which they were going to receive.
Which I think is the point that my Lord was
I think my Lord answered the point, yes.
All right, well...
So you've got 2 points, really. What you say that there is both A and F, and the proviso, as a matter of construction, applies only to A.
Yes.
And point 2 is the distribution has to be to a member, and on your case, it's a former member.
It's a former member who's going to...
I see, thank you.
It doesn't... But there would be no statutory purpose in providing it there. And of course, previously there was no such purpose on the same language. There was no such prohibition. Now, my learned friend took you to the judgment of the Court of Appeal to show you that at paragraph 35, Justice of Appeal Field, this is at the record page 17, and he says, well, you can see here where the court fell into error, because at paragraph 34, Justice of Appeal Field deals with the construction of paragraph E as regards the premium payable on redemption or purchase can be provided for out of profits or out of share premium, or in the manner provided for in subsection 5, and that is the 2007. And then he notes the word shall, otherwise to the extent it provides premium payable on redemption can be provided for out of share premium account. It's repeating paragraph F of 34.2. And that is a point.
The word shall doesn't appear in this subsection, does it? I think the word is must, isn't it?
Must. Sorry, yes, must.
That's another slight alternative. There we are.
Yes. Yes, must. And then it repeats the language of F of 34.2, so that dovetails in there. And then he says, further and more significantly, the disjunctive or in the manner provided for in subsection 5 strongly indicates, he says, in my view, that share premium used in this way is not to be treated as payment out of capital by virtue of 37.5a and b. Now, we'll, of course, come on to all that. He then goes on, and this is where my learned friend picks him up, he then goes on to look at paragraph F, dealing with that part of the overall price that is not referable to premium. So we're agreed on that. Then he says that under F, shares may be redeemed or purchased out of profits or out of share premium or out of the proceeds of fresh issue. Now, that's where he's in error, because he's taken the part that deals with share premium. Now, the reasoning in respect of those two sections is, of course, the same. He's using the disjunctive or. But the reasoning isn't cumulative. It's the same in respect of both of those. And the reason that he's going through this exercise, you'll see, is at paragraph 31, page 14. He refers to section 34.2. 34.2 strongly suggests it was not the legislative intention of the payments by a company out of share premium in respect to the redemption or purchase of obtained shares were to be swept into the extended definition of capital contained in 37.5 and thereby made subject to the solvency requirements. Now, that's the issue. And he says it follows it would only be if 37 construed as a whole clearly provided payment out of share premium for the redemption or purchase of shares is to be treated as payment out of capital. A strong indication would be neutralised. So when one gets to 34 and 35, bearing in mind that the court there was not concerned, and nor is this panel concerned on the agreed facts, is not concerned with the lawfulness of the redemption itself. It's been called indivisible, there's one redemption. The court below wasn't concerned with the lawfulness of the redemption. So the construction of subparagraph E, dealt with at paragraph 34, is not affected by any error as to the construction of the supposed subparagraph F at 35. The reasoning works independently for each of E and F. And if he's got F wrong, the reasoning simply doesn't work for F. Well, We know, in this panel, we know that the nominal amount of the share can only be paid out of profits or the proceeds of a fresh issue. We're not concerned with that today. We're concerned with the element of premium.
Why are we not concerned with that? Because of the points we were putting or discussing with Mr. Smith, it's rather odd and perhaps difficult to speak of shares being redeemed at all unless you can lawfully pay for the nominal value of the shares.
Well, my lord, that is a point that we have to, this.
I mean, is it possible to have a situation where you couldn't, accepting that the shares have been redeemed, and we're talking about payment of the redemption monies or premium in respect of redemption, is it sensible to talk of a situation where you can pay part of it and not the whole?
Well, the question is simply whether you've got a lawful debt or not.
I see.
With
So
a lawful debt, you can pay that debt.
you're prepared to argue it on the basis that it would be unlawful to pay the nominal value, but lawful to pay the premium?
Yes.
But surely it is a lawful debt. That it's just unlawful to pay it in certain circumstances. So that if you envisage an insolvency, a proceeding starting a month later, the redeeming shareholder would be a creditor for the full amount and would rank for dividend.
Yes.
Which he couldn't do because it was a lawful debt.
Absolutely. We both agree it's a lawful debt. We both agree the redemption has been effected. Now, for the redemption to be effective,
is probably the right.
Yes, the statutory prohibition is upon paying it in certain circumstances.
well, with respect, my lord, one has to look carefully at which statutory prohibition.
Statutory prohibition against paying it if you are insolvent.
Well,
but I mean,
again, my lord, the question is when does that condition arise? Because if the permission to pay out of share premium account is independent of that test, then it doesn't turn on the question of solvency.
well, yeah, I mean, that goes back to the basic issue that we're arguing about. But if you accept that there's a lawful debt and that you could, for example, prove for the whole of it in a subsequent insolvency, you must be accepting, as it seems to me, that the only prohibition is against its payment pre-insolvency.
Well,
You'd say it's payment in full, because your case, as I understand it, is you can pay the premium element, but you can't pay the nominal element.
my case is, for these purposes, in these proceedings, that we can at the least pay the premium element, yes.
Isn't that a rather topsy-turvy world, though?
Well, not necessarily, because we know we've got the shares have been redeemed. They've been lawfully redeemed.
Yes.
That's the starting point. Now, if that's the starting point, then the question is, what is there to prevent you from paying the premium element of that? What is the prohibition on that?
I see that. And what you say that the parties are prepared to, the law is prepared to treat the nominal value in a very rigorous way, but what really interests the parties to this sort of transactions contemplated in the Cayman Islands is the premium, and the law is prepared to allow that to be paid.
Exactly.
Albeit that it's going to be paid in a way which is potentially not pari passu with other.
Well, that is a very different point. That's a very different point, my lord, and it comes in, interestingly. It's in this context, indeed, perhaps it's even a jury point, because it comes in proceedings where the court has found there wasn't a preference.
Yes.
So the fact that it wasn't paid pari passu can have no effect on the validity of the payment. That's already been determined, and it's been determined against my learned friend.
But the basis of your submission is that the policy is to conserve the nominal value of the capital.
Yes.
And that policy is not infringed by paying the premium.
Yes.
But Section 37 appears to introduce, in the case of investments of this kind, an altogether broader principle than simply the conservation of nominal capital. It's clearly concerned with the whole of the redemption value of the shares.
Well, my Lord says introduce it. I mean,
I think you take issue with that, don't you?
the section has always, the provisions for redemption have always, after a shaky start in 1929, concerned both the nominal value and the premium. They've always concerned the whole element of the payment. Yes. And they have made provision for that, saying that there are particular restrictions in respect of each element separately. And the position in respect of premium is more lax than it is in respect of nominal value. And it's more lax in two ways. One is because you can use share premium account for that purpose. And the second is because you don't have to carry to a capital redemption reserve the amount, the nominal element. Maintenance of capital is concerned with the nominal amount of that share. Questions of paying the premium are not maintenance of capital issues, strictly so called, common law. It's just a question of what the statute allows you to do with the share premium account, that which at common law is profit. Can you distribute that element to shareholders, even if you can't distribute the capital element to shareholders? That's what's at issue. Now, if one thinks about it, let's say at common law, you clearly could distribute the profit element in respect of the share. What you can't do is buy in the share, and it's the nominal amount that is sacrosanct. So when we look at this section, the question of whether 37 subsection 5 is an overlay to the existing conditions for the redemption of shares, or whether it is an additional gateway which companies may go through if they wish, is of course an important one. But it doesn't follow that because that gateway exists, it governs that which had previously been lawful, namely the use of share premium to make the payment. I should say to provide for the payment. It may be unfortunate that the Cayman law has developed so as to allow a time to elapse between redemption and payment. When it comes to questions of payment, of course, one isn't paying out of a particular fund that is designated as profit or a fund that is designated as share premium. One's simply paying out of the bank account of the company. The question is how that's accounted for. If you have accounted for the premium as one of the lawful preconditions of redemption by providing out of share premium account, then you simply draw on that provision when you make the payment subsequently. And if you think about the order in which the payment is made, should it be made premium first, nominal second, or do you have to pay the element of nominal before you can pay any premium? Well, given that the shares are now redeemed, the answer must be you can pay the premium before you can pay the nominal. That's consistent with maintenance of capital principles. Because you're paying out of the soft capital share premium account rather than the hard capital. But my Lord, critically, the question here is simply, was the redemption, or given that the redemption was lawful, what is there to prevent any element of this debt being paid? Is it a unitary debt that can only be paid if it's paid in full? Is it a unitary debt that can only be paid if an element of it, some element of it, is paid from profits? And there's nothing, I think, in the legislation, once the conditions for redemption are satisfied, really to help you very much on that, save for this, that the Act does require that provision is made out of the share premium account for payment of the premium. So we've got a fund, if you like, a ring-fenced element coming from the share premium account that is there to pay the premium. Now, can that be paid if the nominal isn't paid as well? There's nothing to restrict that. Of course, if redemption itself, the validity of the redemption itself, turns on the payment of the nominal amount, then I'd agree that you can't pay the premium because you haven't then got a redeemed share. But once you separate these things out and you say, well, you have got a redeemed share, the only thing that exists is a debt. Is that a debt that has to be paid all at once or not at all? There's nothing here that tells you that that's the case. There's no policy reason for that being the case once you've separated it out.
And you say also that there's no reason, I'm just trying to relate Section 37.3 with Section 37.5. When you look at E and F in 3, there's no reason to treat E as subject in all respects to 5. Indeed, 5 is only one of the 3 possibilities in E.
Yes.
If you can adopt the share premium account way, then you never get near the problem about using capital.
Yes.
And the reason you say, for the reference to subsection 5 being tagged on in 1989 to E, is probably because part of subsection 5, E of subsection 5 actually, does seem to deal with premium, but the rest of it isn't, you see.
It does. I mean, interestingly, as I think my learned friend pointed out to you, when this provision first came in 1987, the provision, it's at 555H. Or if one looks at perhaps 555F first, looking at section 34, as it was first amended in 1987, you'll see the language is the same, but E, the premium, if any, must have been provided for out of profits or out of the company's share premium account before at the same time the shares redeemed to purchase. And then F, subject to the provisions of subsection 5, shares may only be redeemed or purchased out of profits of the company or the proceeds of a fresh issue. So when first enacted, E didn't include an additional permission to use 5.
Right.
Although, as my Lord rightly says...
Comes in 1989. Is it?
No, that comes in 2007.
No, are you sure?
Did 2007
Sorry,
change the terms at all? I thought it.
Sorry, that was one of the amendments.
It consolidated 87 and 89.
My Lord's quite right. That came in 89. So that was changed in 89, so that the language of E and F changed. So whereas previously E was wholly independent of 5, there was no reference to it at all. In 89, and now in the 2007 Act, both E and F are said to be mandatory as they were before. They've gone back to their earlier language, but with the addition of or in the manner provided for in subsection 5 thrown in. So it's an additional possibility. That additional possibility initially was only put in respect of the nominal amount at F.
Is that right? I'm sure you're right. We'll find that.
Well, in 8.7, I mean, it's simply that there was no reference to subsection 5 in 34E as enacted by the 87 amendment. And then the legislature added an additional way of providing for the premium, namely by way of subsection 5. So the effect of that, if just one thinks of the effect of this, of these changes on E and F, the effect is that without a solvency requirement, the position is exactly as it was before. Shares may only be redeemed if the premium is provided for out of profits or share premium account, and if the nominal amount is provided out of profits or the proceeds of a fresh issue. That was the pre-existing position, and that isn't subject to any solvency requirement. The effect of the 2007 Act, this came in 89, the effect is that there is an additional way in which those two statutory preconditions to redemption can be satisfied. One, in respect of the premium, is that with subsection 5, the solvency requirement, the premium can come essentially from anywhere, very broadly. Two, is in respect of the nominal amount subject to solvency can also come from anywhere, including share premium account.
But subject to the solvency.
Subject to solvency.
So that's the effect of the addition of
That's the effect.
in the manner provided for in subsection 5.
Yes.
Yeah.
But it makes no sense under E to say that share premium account must be used in the manner provided in subsection 5 when there's already a permission to use it without subsection 5.
Yes, so you say the addition of the disjunctive and then the words in the manner provided for in subsection 5 doesn't introduce a solvency requirement at all in relation to the premium.
Yes.
If the premium is being paid out of the SBA.
That's right. And that was the way Justice of Appeal Field in the Court of Appeal below dealt with it. Now, whereas my learned friend's criticism is that he went on to deal with F on an incorrect basis. But that doesn't affect the reasoning, which is exactly the reasoning we've just been discussing in respect of subsection E.
You've still got to get over F.
You've got to get over.
You've still got to treat F as limited in a way that it doesn't say it is.
Of course.
I mean, it may be that there's a mistake which was put right in 2011 when they actually made sure that E and F worked together. But at the moment, F only works in your sense if you treat it, the sort of words in parentheses, as respects the nominal amount. Because on its face...
I agree, that's my case.
Yeah.
That's my case.
Yeah.
No,
Yes.
well, that's my case, that F only relates to the nominal amount, certainly.
Yeah. I mean, when I first looked at this case, it seemed to be a fairly simple point under F that it doesn't allow you to do what you say you do. Once you sort of go on through all this elaborate process, then the question is, have you done enough to force, as it were, to insert some words into F to give coherence to the whole scheme? In your case,
Well, with respect, my lord, I don't need to insert any words into F. I merely need to say two things. One is that F applies to the nominal only and not the premium.
yeah, which it doesn't say, so you are inserting words.
Well, I think, I mean, I'm just looking at my notes of Mr. Smith's argument, and he'll correct me, but as I understood it, as I noted, he accepts that Section 37 3F doesn't include the premium.
Yes.
And that there is this distinction between the two, which got back to front, as he pointed out.
It's got back to
with
front.
history.
It-
Yes, and it's rather odd that it's got back to front.
Well, it may be back to front. It may, on the other hand, reflect what I said about the order of
Commercial
dealing
reality.
with soft capital first and then the hard capital later, maybe another way of dealing with it.
I hear what he says, but I mean, that's really where we started, right at the beginning, and when I said, aren't we getting a bit ahead of ourselves, because I wanted to be clear of
My Lord, I
what we
understand.
actually were saying about F, which
Yes.
is of fundamental importance.
I understand.
You're presumably going to come to 5A in a moment.
My Lord, I'll come to 5A.
I understand that the principal case against you is that 5A, in the part that begins otherwise than, doesn't include share premium account, so that a payment out of share premium account is prima facie caught by the deeming provision in B,
Yes.
and therefore caught by 6.
Yes.
It's not really a 3F prohibition, but a 6 prohibition, because it's a deemed capital payment that you're having to deal with.
Yes, the question is whether you construe that and E together so as to say that E allows you to use share premium account free of that provision, free of subsection 5, or whether subsection 5 is obligatory in the case of share premium account because the language doesn't include it.
And what I'm struggling with is that payment in respect of the redemption of purchase is an inclusive sort of phrase which is on the face of it apt to include a payment of premium.
It must do, my Lord, because when we go on to 5E, if the capital payment is greater than the nominal amount, etc., etc.
Yeah.
So we know it does.
Yeah.
My Lord's quite right. I mean, quite apart from the language that's used.
So that unless A in 5 is just part of a separate gateway and has no wider purpose, if it has any general effect, it appears to treat as a deemed capital payment a payment out of share premium account.
My Lord, I appreciate that point.
And if it does that, then I think you're in trouble under 6, aren't you?
Yes.
Yeah.
And that's the issue that the Court of Appeal essentially had to deal with.
Yeah.
In other words, is one driven by the language of the Act as a whole to conclude that 5A does require any payment from share premium account to be treated as a payment out of capital? Because
Payment out of capital.
a deemed payment.
Not an actual one, but a deemed one.
A deemed payment out of capital. That's right, and subject to the solvency.
B makes clear.
B makes clear.
It's
And-
only deemed whether it would be otherwise or not.
Yes, and subject to the solvency requirement accordingly. Now, that is something that can only be answered in my submission by looking at the separate references in both Section 34 and Section 37 to share premium account. So if one starts with Section 34(2), you look at the specific provisions for which share premium account can be used. One of them is C, that it can be used in the manner provided in Section 37. And I was going to submit, but my learned friend got there before me, that that must mean 37.5.
Sorry, I'm not with you. Just go back to that. The question is when you're looking at what?
34.2C.
Yeah. Yes, quite.
That must mean in the manner provided by Section 37.5, because if not, the manner provided in Section 37.3E has already been dealt with in 2F.
Yeah.
They've already been dealt with. It's expressly dealt with in F. So the question really is, when you look at 2F as distinct from 2C, and when you look at 37.3E and the disjunctive, the reference to share premium account in E, what meaning does that have? What meaning do those permissions or requirements have if any use of share premium account is forced into subsection 5? And that's the base on which Justice of Appeal Field held that 5A is not concerned with share premium account. In the context of, not generally, because of course for the purpose of F, purpose of 37F, share premium account will be treated as capital. Clearly, if you're going to use it for the nominal amount of the shares redeemed, it will be treated as capital. So we know that. The question is, what is the effect of the specific provisions which don't relate to nominal amount, but which relate to premium alone? The specific gateways given in 34(2)F and in 37(3)E.
37.3?
37(3)E.
3E, yeah.
And really the point is, I think, as close as that. The way Justice Field looked at it was to say, well, look, given that 34(2)F says this is a lawful use of share premium account, am I required to find that it's subject to the subsection 5B deemed capital when it is being used for that specific purpose? And he found that the reference, the express reference in 34(2)F and the express reference in 37(3)E meant that it wasn't, and the disjunctive or in the manner provided for in subsection 5, meant that it wasn't. Because were that not the case, one could cross out 2F, 34(2)F, that would be OTOs, and one would cross out from 37(3)E the words or out of the company's share premium account. Because if share premium account is always subject to the deemed capital provision, then it can only ever be used in accordance with subsection 5 and subject to the solvency requirement in subsection 6, which is my learned friend's point.
What is the significance in 5A of the opening words subject to this section?
My Lord perhaps is contemplating that that is subject to the specific carve-out in 37E.
Well, that's what I was wondering. I wondered if that might support your case, because the case that I think is being put against you is that 5 comes in to restrict what you would otherwise say was the 37(3)E gateway.
Yes.
And I wondered if that was right.
And on that basis, the subject of this section would be subject to a payment out of share premium account under 37(3)E, a company limited by shares, etc.
That's what I was wondering if that was part of your argument.
Yes. My Lord,
Well, except that 5A is a permission to do something. So subject to this section is envisaging something which may prevent you from doing it.
Yes, that's right, yes.
Yes, but my Lord, that, with respect, is exactly the point. 5A is permissive and...
Subject to anything that forbids it.
Well, subject to anything forbids it, exactly. But
Well, presumably subsection 6 is the prohibition, is it?
That's what's being suggested against you.
Yes.
Yes, but the...
Subsection 6 coupled with the enlarged definition of payment out of capital in 5B.
Yes. And our case is that subsection 5, the whole of subsection 5, is a permissive route that allows you to effect what one would call a payment out of capital. And say it goes back then to simply to the language. What is the purpose of the legislature continuing to allow expressly the payment of premium out of share premium account under 34F and 37(3)(e), if actually it's always subject to provisions of 35, subsection 5. That's the issue. Now, if one considers the matter, let's say, from a policy point of view, it may be permissible to look at the 2011 provisions, to say, well, if there isn't a policy reason against this now, was there a policy reason against it then? The Chief Justice got into trouble with the Court of Appeal for relying on the 2011 Act as an aid to construction. I know my lords won't be led down that path of error, and will keep clearly in your minds that this isn't an aid to construction. But my learned friend started this on an historical basis and looking at it from an historic and policy point of view about maintenance of capital. And if we're going to look at the question of policy and say, well, what is it that, as a matter of policy, required the legislature to do this? Is there some policy ground? Or if we've got a question of construction, which is a difficult question of construction, is policy going to be helpful at all? Well, my lords, I'm going to show it.
I mean, one issue may be whether the legislature is caught up with policy. I mean, I agree it's quite helpful to look at the 2011 Act, because there you sort of get the final thing where actually the share premium account is brought in pretty clearly anywhere. And when you get to 5, it specifically deals with payments other than the share premium account.
Yes.
Whereas the problem may be that in 2007, we've got something which hasn't quite sorted out, hasn't evolved. You know, we're dealing with a stage in evolution. And of course, the other thing, as it was the point we made earlier on, is no one had really sort of thought about the fact that you could have a payment made, a significant gap between redemption and payment, which you don't have under the English law, and probably wasn't highlighted clearly until our decision in the Primeo case. So we may be in a situation where we're having to ask ourselves, well, has the legislation got far enough in 2007 to achieve what you would say is a coherent policy position? Or do we just have to accept it hasn't?
My lord, I'd agree with that, absolutely, subject to this, that before the possibility of a payment out of capital came into play by the subsection 5, when it first came in, the 87 Act, before that came in, share premium account could be used for the payment of premium on redemption of shares. So if we're looking for an historical thread in policy terms, that policy existed at the outset of the creation of the idea of a share premium account. That was already inherent in the share premium account.
But it was initially controlled, wasn't it, as Professor Gower says, by the fact that there probably won't be much premium involved for as long as the whole exercise is limited to preference?
Probably, although, as Professor Gower says, actually preference shares could include equity participation. It's just commercially they tended not to.
Yeah.
But yes, from a...
So you say that's under the 1963 Companies Act?
Under the 63 Companies.
You could use the share premium account?
Yes. And if one's looking for this, the continuation of that policy into the 2007 Act...
There wasn't any capital limitation then at all which could override that, is that right?
No. No. You couldn't pay out of capital.
Came in what, 19?
That was the 87.
87, yeah.
That's the 87 Act.
Yeah, sorry, anyway.
If one's looking to see whether that policy thread continued, notwithstanding the release of premium, if you like, into something of economic value, real economic value, when it went into equity share capital, not just preference shares, you can find that continuing policy thread because the language is exactly the same in respect of the permitted use of the share premium account in section 34 and in 37(3)(e). In other words, if you say, did the legislature intend to row back on the use of the share premium account for the payment of premiums or make it subject to a solvency condition. Well, they left in some pretty strong clues that they weren't proposing to do that because they left in provisions which otherwise would be OTOs. And if one looks at it from a policy point of view, they may have done it in a way which has caused some confusion, possibly even to this panel. But nonetheless, the clear gateways to the use of that share premium account were there in the same language as they were in prior to 1987. So I would suggest one suppose they didn't have a different meaning. One can't say, for example, that the permission in respect of 34.2f and 37.3e continued to apply to preference shares in some different way from applying to non-preference shares, to equity shares.
Certainly an oddity if 5 was intended to cover 37.3e. It's an oddity that 34.2f wasn't struck by the solvency test.
Yes. Yes. So one may conclude that the scheme of the Act is not entirely coherent because there are different strands, there are different permissions in respect of share premiums. It became coherent in 2011 when those strands were pulled together, and indeed there was a further relaxation in respect of share premium account. So it's not an aid to construction, but it may just indicate that those strands, to the extent that we say they existed in 2007, that did exist in 2007 and continued. And so the 2011 revision is at tab 5, and you'll see at paragraph 34, share premium provision changed by the elimination of F. F has gone in the 2011 revision.
Sorry, which page is that?
It's at page 575.
Oh, yes, it's gone. Right, yes.
It's gone.
Yes.
So we now just have any manner provided in section 37, so far as redemption is concerned.
But it's gone because it is
It's gone because,
reinserted, or
no, it's gone because the limitation in respect of the use of share premium account has gone. In respect of the payment of the nominal amount as well as the premium. So if you look then at the new...
I see, but it's gone because now the share premium account may be used even more widely.
Exactly, it can be used...
E and F are widened
Yeah.
Exactly.
in 37, and by contrast, 37.5 deals with things other than the payment from the share premium account.
Right.
So the relationship between the three sections becomes much more coherent and easy to understand.
And in 34.2c, by this time, section 37 really means section 37.
It really means section 37. It means the whole of section 37. Now, I needn't take my lords through it, but you see what's happened. It's been fully integrated into 37. So it's quite clear now that the use of share premium is not subject to a solvency requirement.
The Chief Justice was berated for using Hansard, but it wasn't very helpful, Hansard. There wasn't any other sort of report before this which explains what they thought they were up to.
So, as I say, I don't think you can permissibly use that as an aid to construction, but what you can do is use that as an aid to saying, well, if we've got a difficult question of construction, And if we are looking at any policy question, does the policy come down on saying that share premium account was intended by the legislature to be subject to a solvency requirement when it was used for the payment of premium? Well, it wasn't before, and it wasn't afterwards. What was the policy ground in between? So when my law talks about catching up with policy, I accept that. But it had always been the case that share premium account could be used for the premium, paying the premium on the redemption of preference shares.
But only for preference shares.
Only for preference shares.
I understand it. The solvency test in Cayman came in at the same time as the ability to use the share premium account in relation to equity shares was first permitted.
That's right. And the question is whether at that time the intention was that the share premium would be caught by the solvency, and you have my points on that, that if that were the case, the language of the section would not have given independent gateways as well as the gateway under subsection 5 or in the manner allowed by subsection 5. Same point as the Court of Appeal decided on. My lords, those are the points of construction. And I think that just brings us back briefly before I move on to solvency. So was any place? Yes. To something that has been a point of some difficulty this morning, which is this question of a lawful redemption of shares, and then what happens next in terms of payment, given the language of the section. Now, the language of the section says that before the redemption of shares, the premium payable on redemption has to be provided for out of share premium account, so some sort of reserve has to be created out of share premium account. You then have a redemption of shares which is lawful, because that's what we've got. And the question is, can that premium be paid out of that share premium account reserve, which for these purposes has been excluded from the as-if capital, if it would otherwise have been there. In fact, in 2007, of course, it was no longer as-if capital in Cayman, but one needn't be concerned about that.
I mean, presumably the purpose of the 2011 amendments was to address exactly the sort of problem that this case raises.
Yes.
And had presumably by then raised.
Yes.
So they wanted to make it absolutely clear that even if you're insolvent, as long as in your accounts you've got a sufficiently large share premium account, which you basically ought to have because the shares were issued at a premium, you can use it.
Yes. That's absolutely right. It is now made absolutely clear. We say it was the law beforehand.
Even if you're insolvent, in fact, even if you've been deceived by your master fund.
Yes, but of course we know, and again this panel is responsible for decisions to this effect, that NAVs based on false outcomes are binding. Therefore,
the tree lies where it falls.
The tree lies where it falls.
It occurred to me that the present case might be cutting down a few more trees.
Well, I don't think so, Mollo, because again it comes back to this pari passu question, which I'll come to on the issue of solvency in a moment. But that's what it really comes down to. The legislature, as one has seen, has said, well, look, let's make this absolutely clear. If you're investing in a Cayman fund, you needn't be worried about the solvency. You can get your...
You get your money back, and as long as there's no fraudulent preference, or you can get it in the order in which the company chooses to pay.
Absolutely. And then it is down to fraudulent preference. Then, of course, if there are other creditors and you have been preferred against other creditors, then of course there can be a clawback in that respect. Yeah. In this case, the court held that there wasn't. Yeah. But that's where the remedy lies. The legislature has now made that clear. We say that was the case beforehand, and we say, well, there are good policy reasons why that should be the case, which really, I think, perhaps matters more to do with remedy, but certainly the ability of a shareholder to redeem shares and to take the proceeds, and to pass that those proceeds on to the shareholders, underlying investors and so forth, as will often be the case, is something that the legislature in Cayman regards as important, without those creditors having to worry about the internal solvency of the company. So, before I move on to solvency, which I can deal with briefly, I just want to return to this question of the indivisible payment. The redemption is indivisible. There is a debt. That debt reflects two elements. It reflects the element in respect of premium, and it reflects the element in respect of nominal value. Given that each element of those debts is a lawful debt, the only question for this court is there any restriction on the payment of that debt? Our case is simply this, that if there is a reserve created from share premium in accordance with the Act, out of which that fund can be paid, out of which that debt can be paid to the extent of premium, it can be so paid. My learned friend's case is that the payment of the premium has to come from one source, and the payment of the nominal amount has to come from either the same, if it's profits, or a different source. But there's nothing in the legislation to say that once that debt is a lawful debt, it can't be paid as to the premium element, even if not as to the capital element. If that's wrong, and if Section 37(6) applies, we get on to questions of solvency. My Lords, can I move on to solvency? The respondent's alternative case is that the appellant hasn't established that the company had any creditors beyond redeeming creditors, beyond redeeming shareholders. And as the Chief Justice put it at page 24 of the record, paragraph 3 of his judgment, claim to recover the payments to RMF is in the nature of what's come to be described in the investments industry as a clawback claim. JL's claim recovery on behalf of all creditors, inverted commas, of the 2X fund, said to be those redeemed shareholders who were to be regarded as creditors at the times the payments were made to RMF, but who received no payment for their shares or who received payments which did not satisfy the pari passu principle. This case, at its heart, is about preference and pari passu, but pari passu between redeeming shareholders, because there is no agreement and there is no finding that there were any external creditors.
Well, Mr. Smith asked us to remit that point if need be. What do you
Well, I can't see why my learned friend's entitled to a second trial when he chose not to lead evidence of this at the first trial.
I see. Right.
It's not an agreed fact. If he wanted it, if we wanted a finding, he should have led evidence in respect.
Right.
Now, on the basis of the Chief Justice's findings, of course, there are the redeeming shareholders who are creditors. And the condition for a lawful payment out of capital, 5 by subsection 36, is that immediately following the payment, the company is able to pay its debts as they fall due in the ordinary course of business.
Sorry, where are you reading now?
I'm sorry, my speaking notes.
I see, well,
You can find it in the Act. We can take it from the Act.
I I thought we were looking at the judgment. But we are now.
Sorry, I had moved on from that. The language, well, we'll find at tab 4, page 568, paragraph 6A. I was just paraphrasing.
Yes.
Now, as my learned friend pointed out,
I'm still lost. We're looking
Subsection 6A.
we're back in the section. I thought we were looking
Tab
at your,
4.
your written submissions. We're now 568.
568. That's 6A.
Yeah.
Now, my lords, as my learned friend pointed out, this is a bespoke condition. It goes beyond the general test for insolvency in the company's law. I think the only other place it appears is where we've already seen it, in section 34, in relation to the use of share premium account. The same language is used for making a distribution or paying a dividend to members out of share premium account. The general test for insolvency in the Companies Act is more limited. The ability to pay its debts, here the words have been added as they fall due, and the effect of that addition raises many interesting questions, none of which have to be considered here today, although I know that my lords are going to be troubled in due course with an appeal from Cayman where that is going to be an issue. But the condition then includes a limiting factor. The debts are as they fall due in the ordinary course of business. Meaning of that is somewhat obscure. It's true, as my learned friend again pointed out, I'm happy to acknowledge that the limitation is on the falling due and not on the debt as a matter of the easy language of the section. Falling due in the ordinary course of business. Does that qualify the debts? I think just on the straight language, that's not entirely clear. But I say you don't simply look at the straight language. I say that the provision cannot be intended to apply to redemption debts. That is to say, debts which have arisen upon a redemption of shares and are owed to members. Now, just think about the first principles for a moment. This provision places a limitation on a return of capital for members. In other words, it's a condition, it's a requirement, it's a condition to the relaxation of what would otherwise be a capital maintenance rule, or a quasi-capital maintenance rule, come to that. Now, the purpose of the capital maintenance rule is clear, and we can just get it from two very brief references to the authorities. In Authorities Bundle 1, at tab 27, it's Flitcroft's case to do with the recovery of unlawful dividends from directors. But the passage I'd take you to, it's a oft-cited passage. It's 878, Master of the Rolls Jessel. And what he was considering here was whether it was open to the shareholders to sanction the payment of these unlawful dividends. And he said that that wouldn't be the case. And he says one reason is this. There is a statement that the capital shall be applied for the purposes of the business. And on the faith of that statement, which is sometimes said to be an implied contract with creditors, people dealing with the company give it credit. The creditor has no debtor, but that impalpable thing, the corporation, which has no property except the assets of the business. The creditor, therefore, I may say, gives credit to that capital, gives credit to the company on the faith of the representation that the capital shall be applied only for the purpose of its business, has a right to say the corporation shall keep its capital and not return it to the shareholders, different people, though it may be a right which he cannot enforce otherwise than by a winding up order. And then the second passage, it's even better named Trevor and Whitworth, which is at paragraph 29. And it's just the passage we need be concerned with, the question of whether the company could lawfully purchase its shares and prove that the outstanding monies in the liquidation. At 904, Lord Watson, the paragraph on the bottom third of the page, one of the main objects contemplated by the legislature in restricting the power of limited companies to reduce the amount of their capital as set forth in the memorandum is to protect the interests of the outside public, who may become their creditors. In my opinion, the effect of these statutory restrictions is to prohibit every transaction between a company and a shareholder, by means of which the money already paid to the company in respect of his shares is returned to him, unless the court has sanctioned the transaction. Paid-up capital may be diminished or lost in the course of the company's trading, result which no legislation can prevent. But persons who deal with and give credit to a limited company naturally rely upon the fact that the company is trading with a certain amount of capital already paid. It's entitled to assume no part of the capital which has been paid into the coffers of the company has been subsequently paid out except in the legitimate course of its business. Now, well, as you can see immediately, those considerations are wholly inapplicable to the shareholders themselves, who, as between themselves and in accordance with the contract of the articles, are entitled to the return of their capital, or their share premium, if that's treated as capital. These shareholders may become creditors in the sense that there is a gap between the time at which the shares are redeemed and the time at which payment is made. But are they creditors whom principles of capital maintenance are there to protect? Well, of course, their interest is not maintaining the capital of the company. Their interest is putting their hands into the bucket and pulling out their capital. That's what they did when they redeemed. They've asked for their capital back. There can't be any maintenance of capital principle as against a shareholder who is seeking to recover his capital, albeit at this stage in his capacity as creditor. And there are other people in the
Why not? Because, I mean, he may, as here, have another number of co-creditors. And why should he be entitled to claim payment out by himself if the company is not able to pay out in the ordinary course of its business the other co-creditors in respect of the same redemption date? Because
the answer then, my submission, would turn on questions of preference. Let's suppose that the company said, well, I'll pay you all pari passu what I can afford to pay you. My learned friend's case is that's unlawful. You can't do that unless somehow you stop the due date. So there's some suspension or something of that nature. But my learned friend's case, if the debts are outstanding, you cannot pay the creditors pari passu, because if you can't pay them all, everything they're owed, you're not solvent. Now, of course, you can if you've got profits. But let's just take the example of a company where the investors pay in, they all pay in, nothing happens to the assets, except that one of them, some of it's invested in a long-term bond. The creditors all seek to redeem. The company is able to pay them 90% ratably, it can't do it. Unless, in respect of the 10%, there is some provision which the company is entitled to rely on to say that that money isn't due, because it stopped being due because the director somehow can call a halt to it. Now, my learned friend says, oh, well, this wouldn't happen because creditors won't be part paid because they'll present a winding up petition. Well, this has been happening all the time. This is what the clawback actions are all about in respect of these funds. This court itself, this panel has had to consider what happens when directors suspend redemptions too late, after the redemption date, to which the answer is, well, that's too late, you can't do it. The debt has arisen, you can present a winding up petition. Now, these are very real issues, because there are a number of cases where redemptions have been paid in part and where liquidators are seeking to claw back those payments on the basis of preference. If my learned friend is right, and of course he will have no concern about this, those actions are really being brought on an unnecessarily difficult basis, because you would simply say, well, actually, the payments that you received, even if they weren't preferences, and even if you actually received them all pro rata, you've got to put back into the pot, because the company was not wholly solvent at the time you received them. This all came out of share premium account, because that's how these companies work with the share premium, and therefore those payments have to be returned. Now, that's a possible result, but it's difficult to see in the context of these legislative provisions that the legislature intended, when it was looking to balance the interests of shareholders and creditors, that it was looking at the position as between the shareholders themselves, that the lawfulness of the redemption that the company wants to make and the shareholder wants to receive itself depends upon the ability of the company to pay that shareholder 100%. It's a very strange result, that even a pari passu distribution would be unlawful. That
So you say subsection 6A just simply doesn't apply here?
Yes.
It doesn't apply what? Because it's not dealing with this sort of debt.
Yes. It's not intended to deal with the very payment which it's upon which the lawfulness of which is conditional upon that section.
Lawful, which is
on that section itself. In other words, when you want to make a payment to the creditor, to the shareholders, you don't have to look to see whether you can pay that shareholder in full. You do have to look to see if you've got other people who are oppressing you for their debts, outside creditors, because that is the purpose for which the maintenance of capital provisions are here in the first place. But no shareholder has advanced credit to the company on the strength of its capital base. The shareholders have put in the capital base. They are the capital base, and now they want it out. And it seems highly improbable that the legislature intended to put barriers in the way of getting that money out when no one else, when there were no outside creditors who were affected at all.
But it might be said against you that the articulation of the capital maintenance principle in Flitcroft's case and in Trevor and Whitworth, of course, predated the 1929 Act and certainly did not have within its sights the idea that there could be a redemption of a share which would take effect, making the shareholder an outside creditor from the moment of the redemption.
I'd agree with that, and as I say, as I've said earlier, and the panel has remarked, this is a problem which has arisen, which has been identified, perhaps, in the context of this particular jurisdiction, because of the gap between redemption and payment. It's a problem which doesn't occur under the 1981 Act in England, although interestingly, a recent amendment has allowed a company and redeeming shareholder to agree between themselves that time for payment can be delayed. I think perhaps the legislature didn't know what it was walking into there. But
do we not have to construe a bespoke provision in Cayman in the light of the circumstances in Cayman when the provision was enacted?
yes, absolutely, my lord, one does. And that circumstance was that redeeming the shareholders as creditors, to the extent that the shareholders can be regarded as creditors, are not in the category of persons that this provision is designed to protect, because their interest, qua creditor, is in being paid the money, not in not being paid the money. It's not in the interest of a creditor not to receive money from the company. Well, also,
I do understand the point you're making, but it takes quite an exercise of imagination to read that sort of exception into what's otherwise a fairly bog-standard sort of solvency test.
Up to this point, my lord, that a purposive construction of that section leads one to say that the creditors who are under consideration are not the people whose debts, the lawfulness of whose debts you're wondering if you can pay. That result would be a very strange result. Dear shareholder, I'd love to pay you 90% in the pound, but I can't pay you the remaining 10. The creditor says, well, pay me the 90. Very sorry, well, I can't do that. Why not? Because this provision is for your protection. It's difficult to see where that protection comes. The same is pari passu. I mean, my Lord will appreciate the same will be, as has been the case, and certainly one of the cases that you're going to hear is where the board said, well, we will pay pari passu to our shareholders. And that's coming up to you on a preference claim, not on
Coming up.
It hasn't been set down. I'm going to let you know what the estimate is for the hearing is next week, my lord. But it's in the pipeline. So these are real issues in the context of preference. Of course they are. These creditors competing with each other. But none of them are protected by saying, well, you can't be paid at all. So, my lord, I accept you. My lord says it's a leap of the imagination. If you start out with Trevor and Whitworth, outside creditors, it's not really that much of a leap of the imagination at all. It's the question of who is the class of persons that this is intended to protect. And it's not these shareholders.
The other side of that coin would be if you were looking at a distribution or dividend being paid to members out of the share premium account, would you then, in applying the solvency test under section 34(2), would debts as they fall due in the ordinary course of business in that context include redemption payments?
My lord, mean dividends, distributions? Or did you?
Right.
I'm sorry, I didn't...
Yes, I mean, I'm asking, if you're talking of a distribution or dividend proposed to be paid to members out of a share premium account,
yes,
would you apply the solvency test which is there mentioned in a parallel way as not taking account of redemption obligations or premium redemption obligations? Does your argument involve a difference, or does it apply here?
No, the same is true, because if you think about the payment of a dividend, let's suppose a company declared a dividend, that becomes a debt following its declaration. And so you'd be in the same position in respect of that debt. This is a debt due to the member in its capacity as such. It's not a debt which has arisen out of someone advancing credit to the company on the basis of the capital.
No, but
therefore, again,
when you ask whether the company is able to pay its debts as it fall due in the ordinary course of business, would you take into account there the potential redemption payments the company might have to pay?
my Lord, in that context, the question would be whether the dividend... Sorry, I take my Lord's point. My Lord isn't concerned with the dividend point. My Lord's concerned with where there is both a dividend declared and where there are redemptions. My Lord, I would say that the same would apply, that this is a provision for the protection of outside creditors who give credit to the company.
Yes, I see.
And consistently with my interpretation of the section.
Right. Thank you very much. Mr. Smith? Yes, Mr. Smith.
Thank you, my Lord. If I could just reply on a couple of points briefly. Perhaps I could start with the 2011 law, which I didn't address your lordships on. My learned friend took you to it. We're in the position of saying that that law, in fact, has the opposite effect of that which my learned friend submitted to your lordships. And if I can just show you why we say that. It's behind divider 5 of the First Authorities bundle. Just to highlight for your lordships the relevant changes, which are really, firstly on page 578, in relation to section 37(3). And your lordship will recall really the key change is in F, where the words out of the share premium account have now been introduced, and the word only has been deleted, and likewise there's been some changes within E. Now, the critical point for our purposes is, however, the change which was made to 34(2), because if you go back to page 575, your lordships will see that F was deleted, but what one has remaining are A and C. Now, in terms of looking at using the share premium account to fund redemptions, either as to nominal amount or as to premium, there are only really two gateways possibly open in section 34(2), and that's either A or C. Now, we know so far as C is concerned, that's a reference to section 37(5), which is subject to a solvency test. And so far as A is concerned, that is subject to the solvency test one finds in section 34(2) itself. And F has been deleted. So on the basis of the 2011 Act, when one's using the share premium account, the two routes which are open in section 34(2) both involve the use of a solvency test, and what's said to be the escape route.
Right, because you say that it now must come within distributions now, even if it didn't before.
Well, it's either that, or it's either that, or under C.
But that's a bit difficult, isn't it? Let's assume it doesn't come within distributions before.
Yes.
You're postulating there's a change of meaning. As to C, C actually doesn't permit the use of the share premium account. What it does is prohibit you making a certain payments otherwise than out of the share premium account. The permissive section, it will be said against you, is now 37(3), E and F, isn't it?
Well, that's, yes, I mean, except that is, I mean, if one's looking, though, at the gateways...
And the deletion of F in 34(2) is because there was a choice. You either had to expand it or else you just deleted it and say it's not necessary if you're going to beef up 37(3), E and F.
Yes, but I mean, our answer on F, I mean, is if one treats that as applying to the nominal amount of the shares, for argument's purposes, then if one's making a redemption of the nominal amount of the shares, it's very difficult to see why that isn't a distribution within 34(2)A. I mean, one can have the argument about the premium and say, well, is a return of premium a distribution or not? But so far as the nominal amount is concerned, which on any view is the return of capital to the shareholder, I mean, it's very difficult to see why that isn't a distribution.
Yes, I mean, I see your point, except one would no doubt if when we're arguing the opposite, say, look at the history, and it wasn't originally a distribution, and it isn't a distribution to a member.
Well, no, except that's not right, because within 34.2F, it's only ever previously dealt with the premium in relation to the share premium account. Yeah. And one never had the provision in 37.3EF previously dealing with the nominal amount.
Why, sorry, under the 2011 Act, F is broad and enables you to redeem out of the share premium account. And I would take that as applying both to the nominal amount and the premium.
Right.
And then 5A says that apart from that, you're then subject to the solvency test. But
that's right.
It doesn't make the share premium payment subject to the solvency test.
No, but the only other way, in my submission, the only other gateway that is open to one, so far as the share premium account is concerned, is 34.2A.
37.3F is the gateway.
Well, in my submission, not, because that 37.3E certainly applies to distribution as the premium. But so far as 37.3F is concerned, assuming that relates only to the nominal amount.
But why do we assume that? If we simply come, without having been through what we've been through this morning, to section 37.3F, it simply deals with how you redeem shares.
Well, the easier way, I mean, perhaps then, is if one starts at 34.2A.
But why should we, I mean, we go around in circles, but why should we suddenly construe 34.2A, paying distributions or dividends to members, which it might be thought until now has had a pretty narrow meaning, as suddenly intended to embrace something which has been deleted, and something else.
Well, I mean,
and also to embrace something new completely, namely the nominal.
Well, this is the first time one's had within here the ability to use the share premium account to pay the nominal amount. So the predecessor history in our submission, one doesn't actually gain a lot from. One's got, on the other hand, I think what's accepted to be the normal common law meaning of distribution. And in our submission, if one applies simply that normal meaning, well, a return of the nominal amount is a distribution. So we don't accept the meaning of the statute is necessarily as clear as my learned friend submits.
Do they have a law commission in the Cayman Islands who have parliamentary draftsmen?
Well, they have a draftsman of kind.
They must.
I don't think they have a law commission.
Yes, they must sweat over these things.
It's all in the Attorney General's office.
Done in the Attorney.
But given the opening words to 34.2, why should, which indicate that the enumerated list is not a limitation, why do you need to expand the meaning of A at all?
Well, it's not, but the point about A is it's specifically subject to the proviso. So you've got the requirement of A. I mean, what it basically says is any distribution to a member out of the share premium account is subject to the requirement of the company.
Yeah.
So one's got that requirement. Then the question is, well, what constitutes a distribution for these purposes? And in our submission,
It has its ordinary meaning.
it has its ordinary meaning, and one has for the first time in here the ability to use it to redeem the nominal amount. The redemption of the nominal amount is a distribution.
Yeah.
So one is in the same position. Now, turning then to Section 37 of the 2007 law, which is obviously the critical position, critical provision for our purposes. Obviously, our submission so far as E and F is concerned, these are cumulative in the sense they both have to be satisfied in order for the company to be in a position lawfully to make the redemption payment in respect of the shares. They're cumulative in that sense. They're both requirements that have to be met. Now, I'm not going to repeat the points we've already made why we say that makes sense as a matter of policy, why there wouldn't be much sense to allowing a payment as to premium in circumstances where payment of the nominal amount wasn't permitted, or why one would be applying different tests to those sort of payments. There is, however, a further point I just want to make on the language of E and F. If one starts with F, it says shares may only be redeemed or purchased out of profits of the company. Now there, it's clearly, in my submission, talking about the payment. It's not using redemption in the sense your lordships used it in strategic turnaround and Promeo to mean the conversion of the investor from shareholder to creditor.
No, I mean, I think the trouble, which I think we pointed out in strategic turnaround, is that the legislation is basically drafted without taking account of the probable subsequent development of a gap.
That's right.
Redemption.
That's right. And
payment.
the point certainly your lordship's made in Promeo might be worth
In Promeo, was it?
turning it up. This is in the same authorities bundle behind divider 20. And in particular, it's paragraph 11, because one of the points which Lord Goldsmith made in that case in support of his argument was to say, well, look at all the references to redemption in different provisions of the Act. It's clearly used there in places as denoting and encompassing the process of payment. And your lordship will see, I mean, two of those provisions he relied on, as it happens, was section 37(3) E and F. And it's fair to say, I think the draftsman...
Well, they're the same, are they?
Yes.
These are which law was that? This was 2007 law.
Exactly,
Yes, it was,
exactly.
Yeah.
But my point is simply, first of all, redemption isn't used necessarily in a consistent way throughout section 37. But so far as E and F are concerned, in my submission, it is being used by the draftsman in a way that encompasses the notion of payment. And what one sees that, in my submission, clearly in F, because he talks about maybe redeemed out of profits or out of the proceeds of a fresh issue, or in the manner provided for in subsection 5. So when he says redeemed out of profits, I mean, he's obviously using redemption there to include the concept of paying. And in our submission, there's no reason to read redemption or purchase in any different way in subsection E. Now, reading it in that way, subsection E only applies if there has been a payment of the nominal amount under subsection F.
Why?
Because
It's related not to the premium of any payable on payment of the redemption sum or for the nominal value. It's the premium of any payable on redemption.
on redemption.
And the redemption has occurred. You accept that.
Well, no, that this is the point, you see. I mean, this is the point I'm seeking to make, which is obviously redemption doesn't necessarily have an unvarying meaning throughout the Act. Within F, it quite clearly doesn't simply mean the process at which the investor has changed to become creditor. In F, it quite clearly, I submit, includes and encompasses the process of payment. And in my submission, particularly bearing in mind the genesis of these provisions and that under the prior legislation, F was in fact in a prior position to E, redemption must bear the same meaning in E. In other words, what it's talking about there is the premium, if payable, on redemption, i.e., both when the shareholder has ceased to be an investor and become a creditor, and when he has been paid the nominal amount under E. And likewise, if you go to 34(2)F, which is the gateway provision effectively relied on at this point, and one bears in mind 34(2)F was introduced at the same time as the equivalent provisions in the Companies Act, which became section 37(3) and F. That talks about providing for the premium payable on redemption or purchase of any shares. Now, in my submission, redemption or purchase is to be read there in the same sense as it's used in 37(3)F and E, which are the corresponding provisions, and it means and includes and encompasses payment. And if one treats shares in F as meaning the nominal amount of the shares. What F is basically saying is you can provide the premium payable on redemption, including payment, of the nominal amount. And it's clear that that must mean a lawful payment of the nominal amount. If there's no lawful payment of the nominal amount, then there is no redemption, as it's used in this sense for the purposes of E, or for the purposes of 34(2)F. And that, in our submission, is how one gets there as a matter of language. It makes sense, obviously, because one is then equating the ability to return the nominal amount with the ability to return the premium. Either they both fall due or neither falls due. It reflects the fact that ultimately one has a single liability to make the redemption payment. And it's consistent with the fact, we suggest there is no sensible policy reason for allowing one to be recoverable or not the other. So, my Lord, those are the submissions we make on that as to why E and F have to be read in a way that's cumulative, and in effect, E has to be seen as derivative and dependent on the lawfulness of the payment under F. My Lord, just to pick up a few other points. My learned friend made a number of submissions in relation to subsection E, essentially directing at the point that the share premium account can be used to pay the premium on redemption. Of course, we accept that. That's what it says. Our point is that is the lawfulness of that payment is subject to the lawfulness of the payment as a whole, including the nominal amount pursuant to subsection F. My Lord, there was a reference to the 1963 law, just to pick up on one point in relation to that, which your Lordships find behind divider 1. My learned friend referred your Lordships to section 32 at page 547. And I think he may have made a point based on a misreading of the section. He took your Lordships to the second part of subsection 1. And I think he was seeking to make a point that insofar as the share premium account was used for the purposes set out in subsection 2, it wasn't treated as being part of the share capital of the company. And he relied for those purposes on the wording in the second part of subsection 1. What he didn't note, and I think misread, is that the exception in the second part of subsection 1 only relates to the provisions of the law relating to the reduction of share capital. And so far as subsection 2 is concerned, what that is concerned with in our submission is simply permissions whereby the quasi-capital represented by the share premium account can be used for those purposes. My Lord, so far as...
What are the provisions of this law relating to the reduction of the share capital of the company?
Yes.
What are they, if they aren't, amongst other things, subsection 2?
Well, they are subsection 2, but I think he was seeking to make a point to say that insofar as those were permitted uses, those weren't treated as share capital of the company. Yes, and I think there may have been a misreading of the opening provisions. So, my Lord, so far as solvency is concerned, I mean, the only point we'd make in relation to that, in addition to the points we've made previously, is in relation to the factual question of whether there are, in fact, third-party creditors. There wasn't, in fact, a trial of this action below in the sense of a complete trial on the pleadings. There were a set of issues which, as I understand it, were ordered to be determined and tried by the court effectively as preliminary issues. As it happened, the court did not make a finding on the question of solvency beyond the redemption creditors point. It didn't need to, because it proceeded on the basis the redemption debts failed to be taken into account. If, for whatever reason, that is wrong, I would invite your lordships to remit it back to that point.
We better get a better understanding of precisely what was being tried by Chief Justice Smelly. Do we find the issue somewhere?
Yes, there was, from recollection, there was an order. Your lordships have the originating summons behind divider 15. And it was slightly odd because we were actually the defendants to this action. Yeah. So it started as a declaratory proceeding by my learned friend's clients.
The order talks about a trial.
Yes, there was a trial of
these issues.
Of issues, yes. Yeah. But my point is it was effectively a trial of not the entire action.
The issues here.
Well, there's a defendant's statement of grounds behind divider 19. There's a plaintiff's statement of grounds behind divider 20. The difficulty, obviously, is the court did not make a finding on this point.
And didn't think it needed to.
Didn't think it needed to, because it proceeded on the basis redemption debts were enough, and it concluded, on any view, taking the redemption debts into account, the company is solvent. So,
do you say, was it given the evidence on which it could have made a finding, or was it understood that
well, what it had
factual findings were to be left over in some respect? That's what I haven't got a grasp of at the moment.
We may have to check that. What it had was the statement of agreed facts behind divider 21, and what wasn't. And I think I showed your lordships earlier the table at paragraph 29 behind divider 269.
And there's a statement of non-agreed facts. Was evidence
Yes.
was evidence used with a view to proving those?
Well, what there was the table at paragraph 29, which I showed your lordships earlier, where there was agreement.
But he was being asked, looking at the grounds, to reach conclusions as to the outcome of the action, wasn't he? I.e., whether they were repayable or not. He was being asked to, on the face of it.
Yes, there's certainly issues were left aside. So, for example, there is a constructive trust argument, which would be in the alternative to the restitution claim, and the Grand Court was not asked to deal with that, and that was essentially left over. So it didn't deal with necessarily all the issues that arose on the pleadings.
We're going to go on tomorrow. So
yes, if you
would it be more productive if you thought about it a little bit more?
Yes.
And just tried to help us with references.
But we'll try and find out what
helpful if you and Mr. Chivers could, as far as possible, agree what this trial was about.
Yes.
It wasn't about, or identify any difference between you.
Right. Well, we'll try and find what the evidence was or wasn't. Yes. That was,
it's clearly about whether the company was insolvent or not.
Yes.
Commercially insolvent, because otherwise the preference issue, which was fully tried and resolved, couldn't have been resolved. It was a threshold question on that part of it.
Oh, yes, and the Grand Court quite clearly made findings of cash flow solvency, but what they didn't do was make the hypothetical finding, or was it insolvent even if you ignored the redemption?
Maybe one of those cases where the court's decided on a certain assumption of law, you say was right,
yes.
They say was wrong. If it was wrong, we don't have the factual findings to address the underlying question on the alternative view about the law.
Well, that's basically the position as it stands, and the question is...
I think Mr. Chivers may be saying that you just didn't have the evidence, the reason you didn't get the findings. Anyway, come, if you wouldn't mind doing your best overnight without
Thank you, my lord. I mean, that was all I was going to say by way of reply,
Yes.
Subject to your lordships.
Now, we've got a relatively short time. You could if you liked, begin with
Yeah.
restitution or whatever
Yes.
heading you put it under.
Absolutely. So this is the final of our three topics, which I referred to earlier. It's dealt with in section G of our written case, paragraphs 104 to 120. Again, I think the first point I need to deal with is a point that's taken against us about remission to the Grand Court again. This time, it's my learned friend whose first argument is to say that this
should be remitted.
Yes. Now, absolutely right. The question of remedy was not dealt with by either the Grand Court or the Court of Appeal. They didn't do so, given they were against us on the issue as to construction of the Companies Law. Therefore, the point didn't arise. Now, the principal issue, which in our submission arises in relation to remedy, is a point of law, ultimately. It's whether there is a right of restitution in these circumstances. And that's a point which your lordships are capable of dealing with, and indeed which is appropriate in my submission for your lordships to deal with. There's not much point, I would suggest, in going back to the Grand Court and coming back all the way up the appeal ladder again, as might well be the case, potentially just to have another hearing. Now, the facts relating to the restitution claim in our submission are largely uncontroversial. The points which are taken against us, as far as I can see, are essentially legal points. There is no remedy because the statute doesn't confer one, and so on and so forth. The respondent has now explicitly abandoned its previous change of position defence. So it seems to us that the only facts which are relevant are the facts of the payments themselves, which are agreed, and potentially the facts relating to the issue which we've already been debating around solvency. So
Facts relating to notice, if there is an issue about that, and it's relevant in law.
facts relating to notice.
Yes, I mean, as I understand it, Mr. Chivers is submitting, among other things, that this is actually governed by Barnes and Addy.
It is. Now,
On that footing, notice would become relevant.
exactly. No,
There
so
are
far
no
as
findings.
Barnes and Addy is concerned, and this goes to the constructive trust point I mentioned a moment ago, we're not asking your lordships to decide that, and obviously the question
No, if it is Barnes and Addy, it has to go back
yes,
to decide whether there was notice.
exactly. So
Are
constructive
we being
trust.
asked to decide whether it's Barnes and Addy?
Well, I think your lordships, the point I think Mr. Chivers puts to your lordship is to say the remedy here lies in Barnes and Addy and nowhere else.
Yes.
And it's Barnes and Addy or bust. And I
Yes.
think
Well, now, are we being invited to decide whether that submission is correct?
you are, yes. But that's essentially a legal submission,
Yes.
which is
And if it is correct, then it's got to go back for a finding to be made about notice.
that's right. That's right. So
I think the point, which is perhaps a rather non-legal point, which is of some interest, is that this is pretty important for the Cayman Islands, and the consequences of your case could be regarded as quite radical there. For us to impose it on them without having heard their views might be undesirable in general terms. On the other hand, as you say, it may be a pure point of law, so we'll have to,
Yes.
I think what we want to do is work out just what the issues are and
yes.
how appropriate it is for us to deal with them.
Right. Well, let me move on and develop our point. The question ultimately is whether there is a right of restitution exercisable by a company in liquidation for recovery of a payment made in redemption of shares, which was not permitted under the relevant statute, in this case the relevant provisions of the 2007 law. Now we say that there is. Our starting point is that such a payment would be unlawful, if we're right on the submissions that I've made to your lordship before, either under section 34.2 or under section 37.6. Essentially
The payment would be unlawful, but the redemption would not. Is that
correct.
Now, if the redemption is lawful, then there was a lawful debt created. And whether rightly or wrongly, the debt was partly paid. So a sum of money was received in discharge of a valid obligation. Now, normally, a receipt of a payment by the defendant is not regarded as unjust if it's a discharge of an obligation. Now, it might be said that if that is so, and we're dealing here with, at least so far as to the extent of the money that was paid, an executed obligation, it might be said that restitution has no place at all, and that the question is accordingly whether there is a constructive trust by virtue of notice that the money was being paid, admittedly in discharge of a lawful debt, but out of funds which were not properly being used for that purpose by the company.
Yes. I mean, your Lordship's right, obviously, as a matter of general principle. I think it's Barclays Bank and Sims, I mean, your Lordship referred to it in Fairfield. The payment made in discharge of a valid debt will not sound in the right of restitution. Now, the difference here is one is in a situation where, if we're right, the payment is explicitly unlawful. Moreover, it's rendered unlawful.
The payment by the company.
Yes.
Yes. Can't be said that the recipient was party to any illegality.
No, it's not said, but in my submission, that isn't necessary, because the position here is the payment was unlawful. Therefore, we'd submit there is a right to restitution of it, and the question is whether the company, in making the payment, is in effect be regarded as in pari delicto, at least with the recipient, thereby to debar its right of recovery.
And that needs a rather slightly odd consequence, but because, as I understand it, it's common ground, but correct me if it isn't, that although the payment is unlawful, being a genuine debt, once the company was in winding up, that debt could be proved in toto and would rank for a dividend that would count as a discharge of the entire debt. So the unlawfulness of its payment it's a somewhat specific prohibition of payment in particular circumstances. It doesn't make the debt non-payable for all purposes or at all times.
Well, no, it doesn't. I mean, certainly, so far as the statutory scheme in liquidation is concerned, there's no bar to the creditor as he's now become proving and receiving a dividend pari passu alongside other creditors. But I mean, that really goes to one of our key points in relation to this, which is the purpose of the prohibition. And one asks oneself, well, what is the purpose of rendering the payment unlawful?
If you had a classic illegality case, let us say a breach of exchange control rules which made a payment unlawful, in that situation you wouldn't be able to prove for it either.
You wouldn't be able to prove.
You wouldn't be able to prove for it in an insolvency either. If you suppose that there was a rule of law which precluded the payment, such let's suppose exchange control.
Yes.
That would be just as good as an answer to a demand by a solvent company as it would be to as an answer to an attempt to prove in a liquidation.
But I mean, in that case,
but this is quite different.
But to take that case as an example, I mean, one would be in a situation of an unlawful payment, and the question would be, was the company in pari delicto, so its right of recovery is debarred? Now, on that...
In pari...
Well, that would...
I mean, I find in pari delicto rather inappropriate. Yeah, there's no one to be in equal iniquity with.
Okay.
The recipient has not committed any iniquity, it's the company. Anyway.
Well, I mean,
and moreover, he's received a payment
like,
in discharge of a lawful debt which was due to him.
I mean, if one looks at cases like Career Cotta, the predecessor to that's how they tend to frame it.
Yes, but that was a completely different context. I mean, the position there was about the unlawfulness of a letting contract by virtue of the absence of a rent book.
Yes.
I mean, we are miles away from from this sort of classic illegality territory. You've got an illegality in the performance of a contract, which consists in the breach of an obligation that lies upon one party only. I mean, this is just conceptually a different world.
Well, it is, but the question, I mean, in our submission, the analysis is not dissimilar, although the facts are. One starts with the question, well, was the payment illegal? In our submission, if the payment is illegal, then on the basis of cases going back to Smith and Bromley, then an action for money hadn't received will lie. And the question is whether the person seeking recovery is barred from that action because of their own participation in the illegality.
I think you're going to have to show us the cases
Yes.
which bring this rather special situation within that principle.
I think I'm right in saying that both of Lord Mansfield's cases, which are cited in the printed cases, were cases in which the payment was illegal by virtue of facts in which both parties were involved.
Yeah.
Yes.
So, I'm not sure how far that assists in dealing with a case where somebody in entirely good faith receives a sum which is actually due to him, and it's being suggested that he must pay it back, notwithstanding that he had no notice that anything was wrong.
Yes. I mean, I accept there is that potentially important point of distinction on the facts of the cases, but in our submission, taking the analysis through, one starts from the proposition that the payments were unlawful, and one goes to the next stage, which in my submission is borne out by cases like Smith and Bromley, which is where there are unlawful payments, then prima facie there is an action in money hadn't received. In many cases, that will be barred because the person seeking to recover has participated in the illegality themselves, and therefore the action for money hadn't received won't lie. But there is an
Not in this where you have general interests of creditors, you say, behind.
Yes, but there is an exception to that, where the purpose of the prohibition is for the protection of a specific class. And in our case, we would say that the specific class being protected here are the general body of creditors. So we are, by that chain of reasoning, within this line of authority. So it's the protected class cases, basically, one sees described in Goff and Jones.
Shall we go? I mean, you're reasonably confident, are you, both of you, that you're going to finish well within the morning?
Yes.
Shall we go? I mean, we've had an extra half hour today. I suggest we go through the authorities you mentioned tomorrow morning at 10:30.
Thank you, my lord.
Very much indeed.